Hello, everybody. Hello, everybody. Welcome to the live. Welcome to the live. I planned this at the last minute, and I was surprised when I looked at YouTube a minute ago and saw all you guys waiting for me. That's so awesome. YouTube, thank you for the love and the algorithm. Everybody, let everybody know you're here. I'm doing an update on the YSL trial. We had a big ruling from Judge Whitaker today. She decided not to recuse the prosecutors. She rejected Brian Steele's motion to recuse DAs Adriane Love and Simone Hylton. So we're going to get into that. So let everybody know that you're here. Hit a like, give me a comment, say hi, get everybody going in here. We've got a few tuning in, so I appreciate it. Vegas in the house. What's up, Las Vegas? I'm here in Los Angeles. Hopefully we won't have too much noise going on. I live downtown, so you guys might hear the sirens. There's nothing I can do about that. It's part of the excitement of living downtown. Yeah, Turbo Telly, Big Meg, not the little one. Exactly. But yes, we've got some news in the YSL trial. I don't think it was all that unexpected. I mean, I know there's a lot of people disappointed that the new judge hasn't declared a mistrial or denied bail or anything like that. But she has made some significant wins for them. I know we talked about yesterday, somebody said, has Brian Steele won anything? And yes, he has. He's won some pretty significant stuff, I would say. I mean, the bail motion and the mistrial motion being rejected, I know are disappointing to people, but I also I don't think a lot of judges would have granted those. But I don't know. We'll get into it. But everybody, Sam, hey, MTR in the house. It's stuck. North Las Vegas. I've been wanting to do some kind of road trip. In 2020, I took a road trip up through Vegas, went to the national parks in Utah, and then up to Yellowstone and saw Grand Teton and everything. I want to do something like that. But Jacksonville. Kevin from Jacksonville, Florida. Roswell, Georgia. Cocoa Beach, Florida. Hello, love your YSL lives. Thank you so much. Miami. I got to get to Florida. I've never been to Florida, but I've read all about it in Carl Hiaasen books. Kristen, thank you for saying hi. We're going to get into the order here. I'm always surprised when I see the filings in the YSL trial, just being used to federal court. I mean, the judge's ruling is like two pages or something, 2 pages with a little bit into the 3. Hello. Somebody from Australia. That's great. Australia, Charleston. We've got the whole crowd. It's amazing the worldwide interest in the Young Thug trial. What I've noticed is a lot of people on TikTok, where I'm not live right now, but I should have. But I've got a ton of followers on there, and there's a lot of people from like South Africa and around the world who comment on the Young Thug stuff. Dee, she's from Tampa. Ashley, you're right there in the thick of things in the ATL. I'm hoping to get over there and visit everybody. We've got Jay Cash from Tampa. Good old Tampa. I had an old editor in Spokane who worked at the Tampa Tribune for a number of years, like during the glory days of newspapers. He was the political editor, took down some politicians, and he was always telling stories about that place. Augusta, Georgia. We got Woodstock, Georgia. Birmingham, Alabama. Good old Florida. Yes, I know all about the Florida man. Texas, Fulton County. Somebody from Fulton County. So, of course, it makes sense that your handle is Justice Matters. I mean, that's the thing. This is such a local story because people are like, what can we do about this? I'm like, well, move to Fulton County and start voting in the district attorney elections. It's just such a Fulton County story. So, somebody from Orange County, Lisa. I used to live down there. I just moved up to LA. But Charlotte, North Carolina. We've got Philadelphia. Hey, I'll get into it here. Thanks for saying hi. Somebody asked if I think there will be a mistrial. At this point, no, because she's rejected, I think, the best arguments for a mistrial. And if she had recused the prosecutors, I think that would have put the motions in play for a mistrial. But I think Bruce Harvey made the best mistrial argument, and she already rejected that. She has not ruled on Doug Weinstein's motion for mistrial, and he's the one who supplemented his motion with information from that June 7th ex parte that everybody's so outraged about, that they just found out about. Though I need to get somebody on here to talk about, or one of the lawyers to talk about when, because I feel like they talked about not June 7th specifically, but there'd been talk about how did this June 10th meeting come into play? And it seems like we heard about some questions about that. But Raleigh, North Carolina, will Thug ever get bond? Not right now. I mean, yeah, I know a lot of people are disappointed with her rejecting all that stuff, but she has made some significant rulings for Brian Steele, just in that she's coming down harder on the prosecutors. I mean, we saw her kind of regulate on DA Love a little bit and call her out on some inaccuracies or untruths that she saw in her filings, which I think stuff like that is significant for them, that they have a new judge who's willing to do that. And she seems much more on the ball in denying or in deciding issues. Like she's much more capable of like handling like a complex trial here. But here is her ruling denying the motion to disqualify. And remember, this is the one where we were wondering if perhaps Fani Willis herself would show up in court to defend this, because she's the one who signed the opposition to this and just said that they hadn't cited any facts or case law in the motion to actually justify a disqualification of them. So I remember, if people saw my talk with Doug Weinstein the other night, we were thinking that would Fani actually show up in court and think this was significant enough that she needed to be there. But she wasn't there on Tuesday when they argued this. And I think when you actually look at this and look at the ruling, I mean, I don't think they thought that there was really any chance the judge would grant this, because the actual legal argument for recusing them, it really just seemed to ride on the idea that they needed to be witnesses in the trial. And the judge explained in a clip I should bring up, she was questioning Brian Steele about that on Monday. And just from the way she was questioning him, you could kind of tell she was not into that. She didn't think that the prosecutors needed to be questioned, and that he can get all the information that he needs from using the transcript himself to question Woody about the June 10th. But we'll see if we can bring up this clip of her, because she kind of alluded that she was going to do this.
Where Mr. Copeland testified. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015, that you found yourself in an office with a judge? We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015, that you found yourself in an office with a judge? Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly. You spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript, and I know everybody has said, oh, there was Brady in there. Y'all got it all now, so it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify on some, maybe all of the things that happen in there. That may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So
we're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions.
I feel like there's another clip too where she talks about that. But it was in that discussion on Tuesday where she made it clear that she didn't think the prosecutors needed to be called as witnesses, that DA Love's motivation for the meeting isn't really the point, that the meeting is the point, and then he can talk about that in his questioning of Woody. So here's her actual ruling. Like I said, it's pretty short, but somebody asked about a new filing. Probably, she probably denied review. to stay the case to allow immediate review of the disqualification. But really, there just wasn't, frankly, a very good legal argument for doing this. I mean, his real legal argument seemed to depend on the fact that he wants to call them as prosecutors. I know, like, all the social media talk is about, corruption and misconduct and everything, but with there being no finding of that so far, there's just, that wasn't even a legal argument from Brian Steele. I noticed this response here. And this guy, I've seen his replies before. This is to Thugger Daily, who tweeted the ruling, the rejection. And this guy is in no way a defender of the DA's office. I see his comments on there, and he said, or at least I don't think he is. It's hard to keep him all track sometimes. But he says, a lot of people angry in the replies, but I genuinely don't think Steele made the argument successfully in front of the judge. A lot of the people are complaining about things that are, one, are answered in the transcript, or two, things Steele didn't even pose to the judge. And that's the thing. Most of his argument was about the witness issue, and the judge explained that the DA loves motivations for the meetings that's not relevant to the case at hand, and that if Steele wants to make an argument that, this is a pattern of conduct by prosecutors, he can make that argument based on the testimony that he elicits from Woody over this. So then we had the ruling here, which is, again, this is just happened a few minutes ago. Judge Paige Whitaker in the Young Thug YSL trial rejected Brian Steele's motion to disqualify DAs Love and Hylton from the case. And this is her formal ruling on that. She says that there's really no legal justification for it. And she has not yet ruled on the final mistrial request. But this order denying the motion to disqualify Love and Hylton was just issued a few minutes ago. And at the same time, Brian Steele has filed his request for a jury instruction related to something that he discussed with Judge Whitaker about Judge Glanville's comments disparaging him in front of the jury. And at the same time, he wants the jury to be told that Judge Glanville is off the case. And Judge Whitaker was pushing back against that, but she hasn't formally decided what she's going to tell the jury yet. So Steele combined the two. His invitation to propose a jury instruction, he's combined that with his hope that the jury will be informed about what happened with Judge Glanville. And this is his proposed language for the instruction. And in my experience, it's really common for what's actually adopted to end up being kind of different from what both sides proposed. But this is his best case scenario, what he would like the jury to hear. Ladies and gentlemen, Judge Ural Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. In a trial, none of the decisions of the court and nothing that any judge says is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based solely on the evidence admitted during the trial and the law I will explain to you. And that's the end of it. I definitely think the middle paragraph, I don't see anything objectionable about that, but I bet prosecutors are not going to like the first and the last one. And I think the judge has already kind of said she doesn't think that the jury needs to be told anything specific about it. But again, she hasn't specifically made a ruling, and she told Steele to file something. But she did invite him to propose a jury instruction regarding the judge's remarks. So he was smart to combine it into two. But it'll be interesting to see what she actually adopts, because it's not. I haven't seen this very often, but she was talking about how, it's not uncommon for a judge, when she was talking about just a judge taking over a trial like this, because Bruce Harvey's argument for a mistrial was all about, when there's a motion for judgment at the end of a trial, how can she be the one to decide that when she hasn't seen the whole trial? And she was saying, really, it's not uncommon for other judges in the Superior Court system in Georgia to decide those motions. So again, the news today is that Judge Whitaker in the Young Thug YSL trial has rejected Brian Steele's motion to disqualify Chief Deputy District Attorney Adriane Love and Simone Hylton from the case. And his disqualification motion cited that June 10th ex parte meeting between Glanville and Woody that has become so infamous now, and said that the prosecutors, by having this meeting, have put themselves in the position of needing to be witnesses in the case, and that because of that, they can't be also be prosecutors at the same time. But Judge Whitaker disagreed and issued this order denying Defendant Williams' motion to disqualify lawyers Love and Hylton. And of course, Defendant Williams is Jeffrey Williams, who's the rapper Young Thug. But she says that a defendant seeking disqualification of prosecutors in a trial bears a heavy burden of proving that such an extreme action is warranted. The party moving for disqualification of a lawyer must generally show that the lawyer is likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact, and that there is no other evidence available to prove these facts. So as the judge was saying on the other day, she thinks the fact that that the defense is going to be able to ask Woody about this transcript is enough to cover all that. So, and they don't need to then get Hylton and Love on the stand to question him about this too. Says, and our appellate courts have instructed that the practice of permitting counsel for a party to be called as a witness should be discouraged and a matter of compelling need only. She said there is other evidence available. The text messages at issue were introduced at trial, and the witness has already testified. Oh, and this is response to A. Bennett, because again, that's a good reminder. It wasn't just about DA Love's interactions with Woody. Steele's motion had brought up, I don't know if it's been so long, but A. Bennett, I forget her name. I forget her first name, but she was the one who had the text message exchange with the prosecutors before she testified, and it came out that an investigator for Fulton County, she felt that he'd been harassing her, and we saw all the text messages ourselves. They were introduced during the cross-exam of her by actually pretty memorable cross by Keith Adams, Young Thug's other lawyer. Did a really good job. And to say that it's just alleged harassment or something, it's like, no, you saw the text messages with your own eyes. This guy was being really inappropriate with her. I mean, it's shocking that Fulton County has some investigator employed who was talking to a witness like that, like saying that he wanted to take her out, things like that. I mean, it was totally inappropriate given the position that he was in and the position that she was in. It's like, what the hell is this? But also at the same time, DA Love was really laying it on thick with A. Bennett too, saying, it was like, what was, she wanted to go pick something. She was like, I am so serious. Apparently Bennett was making something, and Love was like, oh, save me some. I want to get some of it. I'm so serious. And part of it, she'd say that it was just banter or something, or friendly banter, but it seemed to kind of, cross the line. And so Steele was using that as an example of, it's not just Kenneth Copeland that this has happened with, and I want to get Love on the stand to ask her about this. But again, here's Judge Whitaker saying they don't need to do that. So when she says the text messages at issue, she's not talking about anything with Woody. She's talking about A. Bennett. And the witness has already testified. A transcript of the June 10th, 2024 ex parte transcript has been filed, and that's regarding Woody. So there are other sources readily available to establish the content of all the matters cited in the motion. It's a pretty long footnote. That's 3 footnotes in one. You always got to read the footnotes. You see some good stuff in footnotes sometimes. But On the date that this motion was argued, July 30th, 2024, just the other day, and prior to the motion being argued, it was placed on the record by the prosecution that a brief ex parte discussion between these two prosecutors and the predecessor trial judge occurred in the courtroom on June 7th, 2024, alerting the judge to the potential need to have the eventual June 10th ex parte meeting. A rough unofficial transcript of that June 7th discussion was immediately ordered by this court and was secured and provided to all counsel at the close of the July 30th proceedings. This court encompasses that June 7th ex parte discussion as well as its consideration of the present motion. Okay, so I was saying last night that just given her comments yesterday, I mean, the judge did tell Max Shard that she thought his characterization of the June 7th meeting was off. But then a little bit later, she said that to DA Love about, if I was a lawyer being talked about like this, I would be a little hot under the collar too. So that seemed to give defense attorneys their best hope that she would find something wrong with this ex parte or some kind of need for the prosecutors to be called as witnesses. But she says right here that no. So again, she hasn't ruled on the final mistrial motion, but I just don't think based on her comments that she's leaning that way. But it's going to be pretty interesting to read her full analysis of this June 7th and June 10th meeting, because it's just been such a topic of debate. Well, the June 10th one has. We didn't know about the June 7th until the other day, but she's going to come out with a full analysis about whether this was proper, whether coercion occurred, that kind of thing. So that's going to be pretty interesting to read. I'm not sure when it's going to be issued, but she could very well be working on it right now. And then the second, let's read what jogs the second footnote first. She says, a defendant argued orally that he must be able to probe why the prosecutors did what they did and said what they said, and only the prosecutors can provide that information. However, why the prosecutors may have engaged as they did is not a relevant, much less material fact for the jury's consideration in its determination of this action. On the question of any potential bias of the predecessor judge for or against either party, a relevancy and materiality evaluation under OCGA yields the same result. So she's saying, yeah, it's not something we're going to get into here in the footnotes. The predecessor judge was recused from this case by order dated July 15th, 2024, based solely on the fact that in his initial handling of the June 2024 defense motions to recuse, he made a record and provided exposition which amounted to opposing the motions, an action disallowed by Uniform Superior Court Rule 25. The court issuing that recusal order specifically noted its confidence, quote, that Judge Glanville can and would continue presiding fairly over this matter if he were not recused. So, yeah, that doesn't bode well for her future ruling about the propriety of those meetings. I mean, like I said, everything she's said has indicated that she doesn't see a problem with them, and until she did say those comments about the June 7th meeting. But, I mean, here she is not wanting to recuse the prosecutors from it. But she says, if any of the predecessor judges' rulings in this case were improper and erroneous, regardless of the potential reason, then assuming a conviction, they can be raised and addressed at a motion for new trial or a direct appeal. I know that probably causes so much outrage because it's like, what the fuck? If there's something wrong, like, can't she go and do it? But given her position as just another Superior Court judge, like, it's a unique position for her to be in. Like, she doesn't feel like she's a review court on anything like that. And it seems like she has made an effort to review stuff that she thinks she can, and that it's still an issue before her, like the hearsay issues regarding some of Woody's testimony, and then just Woody's testimony in general. I think she's going back on there. I see we have a special guest in the chat. Tasha, thank you for tuning in. I know you were here when Doug Weinstein was talking, and this is Diamante Kendrick's mother. I know she is in a lot of the chats and just, wants to follow everything. It's got to be a stressful time in the family with, this going on with her son. So yeah, thank you for being here, Tasha. Hopefully the new judge, there's some positive changes for you and you feel like the process isn't so stressful and hard. I mean, it's probably kind of hard for that to actually happen, but I know just, having a family member involved in something like this and going to the courthouse all the time, it's just gotta got to wear a lot on you. So thank you for being here. But if anybody, let me pull up the ruling again. Sorry. Here's the ruling here. Sorry, I realized I didn't have it on the screen. It says there is other evidence available. The text messages at issue were introduced at trial. Again, that's about A. Bennett. The witness has already testified. Again, that's Bennett. And then regarding Woody, a transcript of the June 10th ex parte has been filed. So there are other sources readily available to establish the content on all the matters cited in the motion. And he says he doesn't need to, again, Brian Steele was saying he needs to probe why the prosecutors did what they did. However, why the prosecutors may have engaged as they did is not a relevant, much less material fact for the jury's consideration in its determination of this action. Again, and she's talking about the overall RICO case. And she says the same for any potential bias regarding the previous judge for or against either party, and meets the same result. She says, upon consideration of defendant's motion, the state's response, oral argument thereon, and the applicable law, defendant's motion to disqualify prosecutors Love and Hylton because they are allegedly necessary witnesses in this trial is denied. So again, that's the big news today, but I don't think it was completely unexpected for everybody. And I don't think people should get to, I know I've seen some comment, it just depends on who you're looking at, but some people are so discouraged and saying, you know, they'd really been hoping for a mistrial or really been hoping for bail. And they're like, oh, is this new judge any good? But I think the other stuff that she's done, like inviting Brian Steele to introduce this instruction about, you know, a judge disparaging defense counsel, things like that. And then the tone that she's taken with prosecutors, because at least my reading of her comments is that I don't think she thinks Glanville's mismanagement was obviously a problem on this case. And she's made comments about how she can't believe this case has taken so long. And I want to go back and find the clip where she's talking about Woody's interviews. And she goes back and she's like, you know, I cannot believe it took 1, 2, 3, 4, 5, 6 days to go over all this stuff. I mean, obviously she thinks Glanville's management was a problem, but she's said other stuff defending him. I mean, when Max Shard went off, she really kind of said, or actually Doug Weinstein, she said, let's be careful about disparaging esteemed judge, that kind of thing. But she has not taken the same tone with prosecutors. It's obvious to me that she thinks, and not Hylton. I feel a little bit bad for Hylton that she's kind of wrapped up in this whole thing, because I feel like she has differentiated herself from Adriane Love and like her approach to things. But then the ex parte, she's been, you know, lumped in on the same thing because she was in on it too. But just the judge's tone with Adriane Love and her calling her out on, you know, saying you need to take your duty of candor to the court with more seriousness. That's a pretty big deal. And that's not something we ever saw from Glanville. And I think changes like that are significant for them. Let me pull this up here.
And I think sometimes it is helpful to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. I should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. This was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the 2 transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right.
So yeah, so I mean, she does say again that she thinks the attorneys are or, you know, exaggerating or taking out of context what's said in here. But remember, after she said that, she said something about, you know, remembering the rules of professionalism, and Adriane Love kind of hopped up, wanted to seize on that. And look what happened. And this to me just shows, like, Judge Whitaker definitely has a problem with Love. Like, and it'll be interesting to see how it grows over the case, because she's taken the same kind of tone and disagreement with Brian Steele, like when they were going through the transcript of the ex parte, and she was just kind of shooting down his interpretations of things. But it's worse the way it happened with DA Love. And in the end, I mean, Brian Steele has a role to play in that he's advocating for his client. So, like, I mean, it's somebody, a judge in another case once put it as, you know, defense attorneys have a duty to kind of throw things at the wall and see what sticks for their client. But prosecutors need to be taking more of a coherent stance, because they're representing the law, the state. They can take people's liberties. So I think the reaction that we're seeing and kind of the pushback against Love represents some significant concerns that Judge Whitaker seems to have about her here. But here, where is that?
I'd like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay?
I'd like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to.
So yeah, I think when that happened the other day, it gave people, at least it gave some kind of inclination that maybe she's going to find something wrong with these ex partes. And again, she actually hasn't made her full ruling on those ex partes. We're going to see that later on. Her ruling on the recusal doesn't get into an analysis on that. So we could still see her, and I think we're going to have to, especially come down on the prosecutors for some of the comments in there, especially in the June 7th one. Although it was Glanville who, if you read the June 7th transcript, just kind of an impromptu of nothing, says something about all the innuendo that the defense attorneys are injecting into this case. It was just kind of an unnecessary comment from him. But it does seem like, just based on her comment to Love right there, Judge Whitaker isn't just going to completely defend everything that happened in those ex partes, but we'll see. I don't think she's going to call a mistrial over it. I mean, she's not going to allow the prosecutors to be called as witness. I just think it's all kind of setting up for, there's not going to be a mistrial, but we're going to see the final ruling on that. I think she's going to get into her analysis of the ex partes. But again, for those who just tuned in, the news today in the Young Thug YSL trial is that Judge Whitaker denied Brian Steele's motion to disqualify the prosecutors, Love and Hylton, over the June 10th ex parte. He was saying that June 10th meeting they had with Judge Glanville before he was recused, and then Woody, the witness, makes it so he has to call them as witnesses in the trial. But the new judge, Judge Whitaker's ruling, says that isn't necessary. And because he doesn't actually need to call them as witnesses, they don't need to be recused and they can stay on the case. So obviously a loss, but there are some other wins for them in this. And then just the tone that the new judge is taking with the prosecutors, I'd say that's a win for the defense. But also new today is we have this motion for jury instructions from Brian Steele, Young Thug's lawyer, Jeffrey Williams. And he says it's in light of the recusal of Judge Glanville, Mr. Williams respectfully requests this honorable court provide the following instruction upon the return of the juror to court for trial, jurors. And this is a combination of him wanting to tell the jury about why Glanville was recused, and then also wanting the jury to be instructed regarding remarks to them. But the thing is, and they're not going to get into all this stuff. The judge has already said that she doesn't think they need to be told about this. But if they are going to be told that he was removed, they need to be told that it had to do with his response to recusal motions, because the defense is still like, when they try to make it act like he was recused because of the ex parte, and that the ex parte was deemed wrong, but it wasn't. That wasn't what happened. And if you look at the ruling, Judge Krause's ruling is actually, she came up with her own reason for even recusing the judge. This whole thing about how judges aren't supposed to defend themselves against recusal motion was not at all argued in any of the motions. So, I mean, I said I didn't think he was going to be recused because I didn't think that a judge would find any reason to recuse him based on the ex parte. And it turns out that was true. But I didn't realize that Georgia law is so clear on judges can't defend themselves against recusal motions, because again, that wasn't even raised in the recusal motions against Judge Glanville. And after he defended himself so much, and that became the basis for Judge Krause recusing him, no one even mentioned that again in their filings. So Judge Krause basically just came up with her own reason to recuse him. So I think and they're not going to, but if for some reason the new judge would agree that the judge needs, or the jury needs to be told something about Judge Glanville's departure, they're not just going to say he was removed as presiding judge, and then because they're kind of implying here that it would be because of comments that he made. And, Brian Steele was saying, where's the law that says the jury can't be told the truth about the judge? It's like, okay, if you're going to tell them about the recusal, you'd think prosecutors would argue they need to tell them that the reason was for his defense on the recusal motions. I mean, it just feels like it gets into more stuff than the judge is ever going to agree to. But the judge did ask them and invite him to propose his own jury instruction about comments that he thought, or disparaging comments and we've heard about this before, the Glanville saying something about Brian Steele being unprepared or unprofessional in front of the jury. And he's been upset about that for a while. And I don't have a clip of it, but I'm sure it's out there somewhere. But when Judge Whitaker was saying, that's in the past, that kind of thing, but she did say, and you can propose a jury instruction or some kind of curative instruction about that, and we'll see. So he's combining that with his hope that the jury gets told about the non-recusal. So. But I just think, the judge has given no indication that she thinks those ex partes are wrong. I think her easiest choice for calling a mistrial would have been Bruce Harvey's motion, and she rejected that. She's defended the ex partes when she can, except for that one comment about how, she'd be a little hot under the collar too. So I just don't see how she'll ever call a mistrial. Drew, thank you for saying that. Drew Cedarquest. I appreciate you tuning in. And April, I always love to see you in here. You're one of the loyal people in the stream. You were in there back in the day when there were like 15 people in there watching some, gang cop testimony or something. So it'll be interesting to see how quickly they get through Woody's testimony with the new judge, and then just when they're going to have the jury back. Again, they didn't do anything today. They're going to be back in court tomorrow morning. But maybe we'll see the jury next week. I think I saw Thugger Daly said that he heard something about she wants the jury back on Wednesday. So I think she's going to make a point, especially next week, of going through, Monday, Tuesday, she could get through all this Woody stuff pretty quick, like the prep for his testimony. And somebody asked if he still has to testify. And that's what they're going to go back and actually start his testimony all over again. Because that's one thing we haven't heard really any argument over. I guess the law is just so clear on it. Nobody is trying to say it can't happen. Is that anything that happened after the recusal motion was filed against Judge Glanville, the first one, Doug Weinstein's, was filed on June 12th, and it ended up being granted. So anything after that happened is invalid in the trial. And that's basically all of Woody's testimony. So the judge was saying it'd be great if both sides could get together and agree that there are some parts of Woody's testimony that don't need to be stricken, but she's not saying they don't need to go back and redo it. So that, of course, prompted Bruce Harvey, the most experienced lawyer in the courtroom, to say, like, how is that even possible? I mean, how like, it just warrants a mistrial for that. But she was pushing back on him on that, and she's not going to call a mistrial over that. So we've got this instruction about Glanville, but then they're also supposed to come up with proposed language for what are they going to tell the jury about Woody's testimony? Like, are they just going to disregard it? Are they going to have to like get rid of their notes or something? But it's definitely going to be a scene later this month when Woody gets back on the stand and they have to ask him all these questions, because somebody says, let love do it this time. And I think the plan is, because next week, apparently Hylton is gone. I don't know if she's got another case or out of town on a professional engagement. She is president of the National Association of Black Prosecutors. I saw that. But I think when they were planning this trial out a few weeks ago or a few months ago, they didn't think that at this point in the trial, Woody would still be testifying. So she had something else planned. And now that they had this huge delay and Woody's back, they were hoping that they could get another witness to testify in place of him. But the defense objected to that. So he's supposed to go next. And if it's next week, she's not going to be in town. And it's going to be Adriane Love who questions him. But I don't know, just judging by how things are going, I'm like, are they going to be really ready for him to be back in town? So yeah, I don't know. Somebody says arrest him for his testimony. Is that legal? And yeah, I mean, the whole contempt of court thing with him was, I don't want to say it's like happens all the time, but it definitely happens across the country that, you know, witnesses are arrested for contempt of court. There was actually a manslaughter case that I covered, federal manslaughter case for the Conception boat that sunk off the coast of Santa Barbara back in 2019. 34 people died. Oh, it was a terrible case. But the prosecutor, or the captain, was prosecuted for manslaughter in federal court. And one of the boat guys, who wasn't charged with a crime or anything, but he was supposed to testify in the trial, they didn't think that he was going to show up. And he actually got arrested a couple days before they called him to the stand. So he was arrested on a witness warrant, material witness warrant. It wasn't contempt, but they can totally do that. He was in jail for a couple of days and he testified. And of course it doesn't get any press attention because, I mean, it's not televised, but yeah, that stuff happens. So it's going to be interesting to read Judge Whitaker's whole analysis of that ex parte and what went down on it. But again, the news today in the Young Thug YSL trial is that Judge Whitaker has rejected Brian Steele's motion to recuse DA's Love and Hylton from the case. Let me see here. Yeah, we got 808 here. Everybody hit the like button if you can. Give me some love here. Let me see if I can pull up another clip. If I like TikTok because it's got so many options for short clips, but let me see if I can find when we're at, because I think I have another clip where she talked about here. This is the discussion where Brian Steele is arguing his motion to recuse the prosecutors, and he's talking about the need to call them as a witness. So this is a couple of days ago where she kind of previews his testimony here.
But the issue, as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need to be kicked out of this case. I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
Thank you.
Okay.
Okay, so this is her right here, the order issued today, thinking about it and then putting in writing basically what she told Brian Steele in that clip. Again, the news today is that Judge Whitaker rejected Brian Steele's motion to disqualify DAs Love and Hylton from the Young Thug trial. So they are going to continue being the prosecutors in this case. He had cited the June 10th ex parte meeting, which is now infamous in the Young Thug trial watcher circles, the meeting between Judge Glanville and Woody about his testimony. He cited that as a reason to kick them off the case because he would need to call them as witnesses to ask them about this. But like the judge said in the clip that we just saw, she doesn't think that their testimony is necessary. And really, that was his only legal argument for actually disqualifying them. And he made that orally too. His written motion didn't have a lot of like coherent legal arguments for disqualifying them. Because remember, as much as he said this point blank that the ex parte has been declared illegal and that it was misconduct, but nobody has actually declared that yet. The judge is going to do her own analysis on that. So we haven't had any kind of findings like that. So with that, I think it was unlikely that Judge Whitaker was going to kick them off the case. But another filing that happened today is Young Thug's lawyer, Brian Steele, doing a proposed jury instruction regarding Judge Glanville's departure and the instruction that the jury should not consider any disparaging remarks that Glanville may have made about defense lawyers in this case. So I really doubt the judge adopts this same language, except for maybe the middle paragraph. But I think that we could see it. We're going to see something like that. So somebody asked what people in the legal community think about this case, at least in like LA and in circles. Like when I talk about this case, I was talking about this case with a Law 360 reporter, Craig, who covers all the same federal trials in LA that I usually cover. And I was just talking about what a circus it is. I was like, the judge being disqualified, all these recusal motions, blah, blah, blah. And he was like, this is a Superior Court case, right? And I was like, oh yeah, of course. And he's like, yeah, it sounds like one. I mean, and Law 360 has a huge presence like all over the United States. They cover tons of trials, but they're not covering the Young Thug trial. And I don't think that there's anything that would actually prompt them to cover it because their readership is lawyers, like practicing lawyers, not law tube lawyers, but big law. That's a big market for them. And when you subscribe to Law 360, you sign up for practice areas that you want to read about. So I'll see them covering a ton of civil trials involving like big companies, trade secrets, that kind of thing. But the criminal cases they file or they cover are usually only in federal court, like white collar cases. And unless they're covering like a really big celebrity case. But yeah, they wouldn't cover the Young Thug trial just because the actual practicing lawyers who read Law 360 have no use for like reading about this Fulton County Superior Court case, but kind of says something about it. But I think a lot of the lawyers just kind of think it's silly, but they're also entertained by it. And I think this gets into, it's such a window into Fulton County politics and like the justice system and is it the South, is it a regional thing? I don't know, but it's kind of crazy, some of this. But again, for anyone who's just tuning in, I want to get a clip. I need to do a good newscaster clip to clip out for my TikTok. So let me read it again. The news here is that Judge Whitaker in the Young Thug YSL trial rejected Young Thug's lawyer Brian Steele's motion to kick the prosecutors off the case. He had said that the June 10th ex parte meeting that the now recused judge, Judge Glanville, had with Woody, the witness, and DAs Love and Hylton made it so he's going to have to call Love and Hylton as witnesses to ask them about this meeting that they had, and then also Love's previous interactions with another witness, A. Bennett, whom she shared a lot of text messages with. But the Judge Whitaker, said in this order issued today that it's not necessary, that with the transcript from the ex parte meeting, Steele is going to be able to ask Woody about this all he wants in cross-examination, and that he doesn't need to then get Love on the stand to ask about her motivations for having this meeting, that it's immaterial to the case at hand. But you can see why she wouldn't say it's immaterial to questioning Woody, because his motivations as a witness are at issue. But having the prosecutor's motivations on trial too, they're saying is not something that needs to happen. So that order was issued today, and it was followed by Steele filing the proposed jury instruction regarding Judge Glanville's departure and the disparaging comments about defense counsel. Please disregard that. So we might see a ruling on the mistrial tomorrow. It seems like we might see some kind of analysis of the January 7th or June 7th, June 10th ex parte. She's guaranteed we're going to. It's just unclear about when she's actually gonna issue it. So let's see. So I think it's just a matter of them plowing through Woody's testimony, the previous statements. What are they going to use for that? And then deciding when exactly is the jury going to come back here. But I thought this was another outstanding issue that Bruce Harvey brought up, the most experienced lawyer in the courtroom. But he doesn't want prosecutors talking to witnesses during their testimony, other than just the questioning that goes on, which just in the cases I've covered, I've definitely seen prosecutors, like during breaks, they'll meet with their witness and talk a few things. And of course, the remedy for that is the defense is allowed to ask them about that on cross-examination. But Bruce is saying that his reading of the law says they're not supposed to be doing any interactions like that. So here, I'll bring it up here. So I think I got it said I lost connection there. Let me here. I see all these people saying that Woody's not going to show up. I'm like, that would be probably overall a mistake on his part, because I'm not sure this judge is quite as happy as discipline happy as Judge Glanville is. But I mean, they're not going to take that. If a witness who's under subpoena just doesn't show up, I think it could definitely be a problem. But yeah, hit the like button. Hit the like button, guys. Let me know you're here. Let me know if you guys can hear this too. It gave me a connection warning, but let me hit play. See somebody saying no volume. Damn. Let me turn that off. I'll get it back up. Yeah, no, I see other people saying, of course, Woody's gonna show up because he loves the act. But yeah, I mean, he could be jailed again if he doesn't. I don't know if they do, if it would be called a material witness warrant, but that's definitely one thing that happens. But yeah, it would be a contempt of court or something that the judge would rule on. And I mean, while this judge, like I said, I don't think she's quite as disciplined and happy as Judge Glanville. She's not going to put up with something like that. if he pleads the fifth again, it would be the same issue where it's like you have immunity, so you can't. So it'll be interesting to see if that does happen, which I kind of don't think it will, but I don't know. Who knows? How the judge handles that opposed to Judge Glanville. Because that's always the thing. I mean, the law is, uniform for all judges, but it just gets into the human aspect of it. Like judges are just human beings. So there's, different personality traits that come into play here. But, so yeah, we should have sound here. Let me know if there's no sound for sure.
After, I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I can write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant.
Okay.
And the defendants.
I see somebody saying elect Trump, he will pardon YSL just like he did Kodak. No, it's a state case, so he can't pardon anybody. And Georgia governor can't even do pardons. And I would urge everybody who's concerned about, prosecutorial misconduct, the things going on with cops, to consider the fact that Trump has just said point blank he wants to expand immunity for everybody. He doesn't think that anybody should be able to be prosecuted for wrongdoing as a police officer or everything. So that whole idea that you should elect Trump because it would be good for young thug is completely freaking wrong. But had to interject there. But yeah, there's no pardon possibility. The president could not pardon young thug, and apparently Georgia state law doesn't even allow for state pardons. So,
Counsel, that was the whole basis of Perry versus Leak.
Right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hylton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that, because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure.
So yeah, they haven't decided that issue. Again, I really don't care who you vote for, but I was just correcting the fact. There's no way anyone can pardon Trump or there's no way anyone can pardon Young Thug. Especially, I was surprised that there's no pardonability even in the state of Georgia. But all that depends on, he would have to be convicted of something for him to be pardoned on anything. So yeah, again, I don't know if there's been anything else today other than just the judge rejecting the wanting to certificate of immediate review. Oh yeah, here's that. Thugger Daily posted it. I think that was pretty expected. I mean, he didn't really put forth a good legal argument for disqualification, so it didn't really have a chance of getting anywhere on appeal. So that was like quickly denied. But yeah, Georgia. It's I'm doing a talk later on real RICO cases coming up here in LA, a federal RICO case against the Mexican mafia, like one of the top Mexican mafia leaders who was running the drug trade in the jail, and a lawyer who's accused of helping them. It starts like October 1st, but it's going to be quite a comparison to a Georgia state RICO case. But says, somebody asks, will Woody need an attorney when he comes back? I'm trying to think if I've ever seen a witness testify who didn't have an attorney. I mean, especially in a case like that. I mean, I guess he didn't after he fired Bumpus, and he thought he didn't need an attorney. I mean, it's up to him, but I'm like, I can't imagine people going up there to testify without some kind of an attorney. But well, maybe not every single witness, like civil cases and that stuff, but especially in a criminal case like that, you'd think he would have an attorney just to advise him, but it's up to him. He doesn't, it's not like he's required to have one. But is it fair to assume that at least one of the jurors has seen coverage and won't find the defendants guilty? I mean, I don't think so. I mean, I'm not sure. I mean, I've heard it kind of both ways. I know a lawyer who thinks that all the jurors always violate that, but then the order not to read news coverage of a case. But then I know a court clerk who worked in state and federal courts in California for like 40 years and actually is the person who deals with the jurors every day, like tends to their needs, like goes to the jury room to talk to them and stuff. And she said she thinks they take that pretty seriously, and that if there is a juror who violates that and they hear about it, they usually rat each other out. And that, I mean, one thing to think about is the jurors have other things to do. So the idea that after they get home from court, they're just so interested in like seeking this stuff out. I think the news coverage is so saturated with it in Atlanta. Like the thought is that it must just be hard for them to avoid it. I mean, even if they aren't actively seeking out the news coverage, chances are they're just going by a TV and there it is or something. I don't know. We haven't heard anything about it, but so yeah, I mean, I don't think we're going to see any kind of issue like that with the juror. And if there was a juror who turns out to have seen something, I think they still have like 3 alternates left. So they would just strike that person and be down an alternate. But so yeah, so the big question is, how is she going to rule on the remaining mistrial motion from Doug Weinstein that incorporates the June 7th ex parte and also the June 10th. And she has said that she is going to, this is the new judge, Judge Whitaker, is going to issue a full analysis of the June 7th and June 10th. So I think that is going to be quite interesting to read. Especially before the June 7th came out and we hadn't heard her comments about that. I was like, I don't think her ruling on the June 10th is going to make the defense very happy. But now that she has indicated she finds some stuff in the June 7th transcript to be a little unsavory. So I think there might at least be a line in there about the prosecutors or something. But I don't know. I don't think she's going to see it as enough for some kind of mistrial. But where we'll see. Somebody asked when she's going to rule on it. I don't know. I bet she's working on it right now. But it seems like maybe tomorrow morning she'll have like the written ruling issued. But I don't know. She could take longer. But one thing is, like I said, I'm always surprised when I see the filings in Fulton County Superior Court because they're not as thorough and as in-depth as the federal filings that I'm used to. So her rulings so far haven't been all that exhaustive, but I think she has a lot to cover going over the ex partes. So it's hard to say when it's going to be, if it's going to be tomorrow or if she's going to issue it next week. But she's made it clear she wants to move forward. So I can see her going ahead. So yeah, does anybody have any questions? Thanks you all for tuning in. We've got a big crowd today. Hit me up, give me a like, give me a subscribe, whatever you can. Yeah, somebody says she can't go on Krause's ruling. She has to make new findings. Yeah, and she made it clear that she thinks it warrants a bigger analysis because while Judge Krause said that she generally agreed with Judge Glanville's analysis of it, she didn't really get into it at all. And there's even one line in there where she says, while the ex parte could have been done in open court and perhaps should have, the perhaps is like, okay, so are you going to like decide this issue or not? I mean, she just kind of made it clear that she didn't really do the full analysis on that because she found another reason to recuse Judge Glanville over his defense on the recusal motion. So thank you for the wave there, Ellery. Appreciate it. She asked the jurors if they've seen anything like the judge did in Karen Reed. I bet it'll be interesting to see how her admonishment is different than Glanville's, but I bet she'll just do the same, you've been told not to read anything about this case, et cetera, et cetera. And if anyone approaches you or if you do see anything on TV about this case, let us know immediately, that kind of thing. So somebody says, why no court today? They weren't ready. They need to get through all of Woody's statements. And she was pissed off at the defense for not being more ready, not having everything ready because she was ready to go through all the evidence, but they didn't have the statements ready on it. So she needed to give them a day. And they're back tomorrow at 8:45 to get going on. But let me see. Yeah, for anybody just joining in, I'll go through the order again. It wasn't anything huge today, although I mean the recusal motion against the prosecutors was huge. I don't think it really, people didn't really think it was going to actually be granted, but people should not see this as a sign that Steele hasn't won anything or anything like that, because just the change in the judge and the way the judge is regulating on the DA a little bit more is good for them. Everybody's saying it was the state not ready. It was all of them who weren't ready, because she was going off on the defense about it too, from what I saw. I mean, she was saying, and Doug Weinstein was saying that, he was, he had all these other court cases to go to and everything. So it was definitely the defense that wasn't ready too. Somebody says, do you think Woody will testify that he was coerced? Probably not. I mean, and that's the thing. What is his testimony? If they were coercing him to testify, he has not testified like what she has not testified like anything bad for them, really. She's just gotten up there and denied saying anything incriminating. So bring it up to show you guys. Let's see here. I might just end it, but I wanted to pull up some new clips for you guys. God, you guys are fucking okay. Yeah, no, I'm gonna keep here and find that clip because even Thugger Daily posted it and said that she was mad at the defense for not being ready. And I mean, and Weinstein was like explaining why they weren't ready. Here. Here it is.
And I'll be candid with the court. I have
happy
several boxes
that the defense was not prepared to revisit the Glanville redactions today. Yeah, guys, it's not just me saying this. Here.
And one of those boxes contains my notes. It got to the point where Ms. Hylton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Shard is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so I, to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So. Okay. All right. So how about another witness?
Yeah, no, it gets into, I mean, people in the comments and stuff will argue stuff the attorneys aren't even arguing. It's like, dude, the judge, and they basically just admitted, yeah, God. But anyway, so tomorrow should be a big day. Really, I was glad they didn't have it today because they went through a lot of stuff and that kind of thing. So again, the big outstanding one is her ruling on the propriety of the ex parte, and the June 7th and the June 10th, which is going to be wrapped into her ruling on, I think, her ruling on Doug Weinstein's mistrial motion. Trying to look through the comments here. I'm trying to get a friend to jump in as a moderator here, because I know I missed some good questions in there. But yeah, I appreciate people apologizing for me on that, because I mean, I saw it. I was like, everybody in the comments was just like, "No, Meghann, they didn't." It's like, all right, I'll go find the clip for you guys, because even Thugger Daily called it that way. But somebody asked of an attorney from the case here in the chat to argue. Not in the chat. I haven't reached out to Doug or Max Shard recently to see if they can get on here. And this was just something I did at the last minute when I saw the rulings. I was like, oh, there's some breaking news, because again, that's the news, is the order rejecting the disqualification motion against DAs Love and Hylton, and then Brian Steele's proposed jury instruction here regarding Glanville's departure and the "don't take any disparaging comments against me seriously" kind of thing. So I think we'll be hearing about that tomorrow morning. No timeline on when we have on when we're going to hear on the ex parte and the mistrial motions, but could be tomorrow. I mean, it seems like the way they're going and the way these rulings are actually not like huge, like, you know, long written federal rulings. We could see something. So thank you all. Somebody points out that this chat does not seem to need much moderation. People are nice. Yeah, I've been fortunate on that too. I've noticed too that I appreciate everybody talking and being nice in here. We can all disagree. You know, people can disagree but not be disagreeable. But I will definitely be on tomorrow morning streaming. I'm not going to be here the entire time, like at my house while this is going on, because actually another case, another rapper in trouble, ASAP Rocky, has a hearing in his criminal case in LA Superior Court. He's not going to be there, but Joe Tacopina, his lawyer, is flying out for a dismissal motion that I think has like zero chance of being granted. But I'm going to go over to that at 8:30, and then I'll be back here and hopefully catch up on everything and do a live for y'all. But I might do something else on that case. So anyway, again, just to kind of sum it up at the end, the news today in the Young Thug YSL trial is that Judge Whitaker has rejected Brian Steele's motion to disqualify DAs Love and Hylton. Steele had said he needed to call them as witnesses because of the June 10th meeting that they had in chambers with Judge Glanville and Kenneth Woody Copeland. He wants to ask DA Love about coercive measures he thinks that she's taken with witnesses such as Woody and then a woman who testified a while back, A. Bennett. But here in the order, Judge Whitaker says she just doesn't think it's necessary, that he has the transcript from the ex parte and he's going to be able to cross-examine Woody about that, and that should be enough to get what he needs. So she sees no reason to disqualify Love or Hylton from the case. And then below this is a proposed jury instruction that Steele has filed regarding Judge Glanville's departure and comments that Judge Glanville has made about him. In particular, Judge Glanville said in front of the jury a while back that he was unprepared and unprofessional. So he wants the Judge Whitaker to read to the jury, "Ladies and gentlemen, Judge Ural Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. In a trial, none of the decisions of the court and nothing that any judge says is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide the case based only on the evidence admitted during the trial and the law I will explain to you." So I doubt the judge is going to adopt that exact language, but there's going to be something like that. I wouldn't be surprised if that middle paragraph sticks as is, but I also wouldn't be surprised if she wants to say disparaging of the lawyers in this case instead of just specifying defense lawyers. But we'll see. They're going to have to read something. They're going to have something to explain this. I mean, not getting into all the details of Glanville's departure, but there's going to be something. And then also they have to come up with something they're going to read to the jury about rewinding Woody's testimony. Like, how are they supposed to disregard this testimony? Are they supposed to destroy their notes? That kind of thing. So that's what we're up against when the trial is back, or case is back for a hearing tomorrow. It's 8:45 a.m. in Atlanta, which is 5:45 a.m. here in Los Angeles. I've been kind of adjusting my sleep schedule for that. So can someone answer about hostile witness? If the prosecutors were to declare, at least in my experience, a hostile witness means that you can ask leading questions when, like on direct exam, when you normally wouldn't be able to. But I don't think they've gotten that with that designation with Woody. So I don't know if we're gonna see that. But anyway, see the comments here. Somebody says, the ASAP case is just so much different than Young Thug. I mean, it's a lot like the Tory Lanez case in that he's charged with the same thing. The facts are totally different, but the Young Thug case is so different in that it's such a huge case with this racketeering conspiracy charge. It's weird. But yeah, so I think that's what we're all looking for is Woody's testimony returning. And then also, how fast are they going to get through Woody and what are they going to do after that? But yeah, somebody says, love the friendship in the chats, Jenny D. And I was kind of noticing that earlier. I was like, oh, there's people like recognizing each other there and like saying hi and stuff. That's cool. Ashley asked, where is the immediate review? They rejected that. Steele filed for it, but it got immediately rejected. So, and the idea, if it wasn't rejected, the appellate court wouldn't really see any legal. I think they'd have to side with Judge Whitaker on that. But still outstanding is the mistrial motion. So we'll look for a ruling on that. But yeah, it is a cool chat. That's cool. I like people going. I'm kind of like reluctant to sign off. I'm like, I hate to like ruin this for people, but I'm frankly just kind of running out of things to say, and I don't want to just go on forever. But I have not seen any other significant rulings. But I'm looking forward to the ruling on the mistrial. Just reading what her take is on the ex partes and everything, and I'll definitely do a ruling on that. So. Yeah, I think that's about it. But yeah, you guys are great. Thanks for tuning in. Give me a like, say hi. Yeah, somebody says, don't worry, you leave. We can keep it going. I'm like, yeah, just keep it live. You guys just keep, there has to be some way to get the chat displayed on the screen, right? There's so much more I can do with YouTube. I got an invite from YouTube creator program for some kind of like manager program for my shorts, because I've been posting all my TikTok clips recently as shorts, and a lot of them have really done well. So apparently I hit some kind of algorithm and they reached out to me to, I don't know what that means, to have like a short clip manager or something, but hopefully it, kind of helps my standing on here. So yeah, let's get the likes up, right? YouTube. Oh, one thing I've got to do, and I'm like, God, fuck. And it's just a different crowd. Like one thing I've noticed, and maybe it's just because the Young Thug case is just so much more legally complicated, but also, and I'm sure this isn't even close to a controversial statement. And here it is. Somebody just mentioned Tory Lanez. Like Young Thug is such a much more famous and accomplished rapper than Tory Lanez. Like, right? That's not even a controversial thing for me to say. But I've just noticed that the crowd that watches the trial is a lot different than the Tory Lanez case. And somebody says, God, I never said Tory Lanez's appeal was rejected. A bunch of people have been reporting that because I think they are confused and they think that the state attorney general's office is like the decider of it. But here, I'll send you guys my article. And this is it. I don't get this with the Young Thug crowd, but the stupidity in these Tory Lanez watchers, it's like they don't even read what I write. It's freaking crazy. But that's my Tory Lanez story. I think if anybody reads it, they'll see I say up high that the 2nd District Court of Appeal has not decided this appeal yet, So, but it's just it was a story on a new filing in his appeal. There's actually another filing that I have that's 140 pages long that I need to read through and write about. But like I said, after covering Young Thug for so long and then going back to the Tory Lanez case, I'm like, wow, there is such a marked difference between the people who pay attention to these two cases. Like, exactly. Like, yeah. But anyway. Somebody says what's going on with Melly. I meant to clip that out too. But Bryson Boom Paul, who did my googly-eyed bitch logo, which, man, I missed an opportunity on that. I saw somebody in the chat earlier ask how they can buy a googly-eyed bitch mug. And I entered the my URL for Meghann the Reporter, but I've got it right here. I still need to get it set up so it's actually attached on my YouTube. But Bryson, who did the googly-eyed bitch logo, also covers the Melly trial. So I had him on a live a while back, just kind of doing an update on the case. And there's really nothing going on with that. They'd set a trial date for late 2025. And, but there's an appeal that is still going on that, gosh, I'll have to, sometime when there's something new, I'll get Bryson on to give an update, because I kind of want to do that, try to get like a virtual newsroom going on, because there's frankly just so many cases going on. It's way more than one person to cover. And Bryson has been following the Melly trial for a while. He followed the first trial. So I want to kind of help give him a platform and stuff to talk about that. But the trial is scheduled in late 2025. And right now there's an appeal going on. So, anyway, see the little guy going off about lanes, stop. I mean, it's that constantly with them. It's kind of gotten me off. Oh God, now he's spamming it. That's why you keep lying about Tory. Dude, I don't give a shit about Tory. Oh my God. All this, I mean, it's crazy, the vitriol around that case. It's like, like I said, the Young Thug case is much more interesting. But do you think the feds will pick up this case if the state loses? Definitely not. Like, I don't think the feds would ever touch this case. I mean, maybe this will spur the feds to look into some of the injustices going on at the Fulton County Jail and that kind of thing. But definitely, they're not going to look at this case and be like, oh, this is a really good RICO case. We should go after these guys. Like, no way. It's like most of their evidence is like a bunch of stuff they posted on Instagram when they were like 17, but that's why I'm looking forward to this Mexican mafia RICO case coming up in LA federal court, because it's a fucking real RICO case. It's not going to be 6 years long. It's going to be like maybe a month-long trial, maybe longer. They actually have 4 defendants on trial, but like the Mexican mafia running drugs in the LA County Jail, like that's the kind of topic that you think the feds would like go after for RICO, and they did. The case was actually filed in 2018, so it's been going on it has been going on for 6 years, but the trial is not going to be 6 years long. So, God, geez, this TV, it's just freaking, and sometimes I think blocking these people is just way more attention than they even deserve. But yeah, God, get them out of here. Anyway, what about the silencers and machine guns? They could. I mean, a lot of these guys have been prosecuted for guns and stuff in court, right? I mean, Young Thug never has he? This is when Thugger Daily comes in very handy, because he knows like all the other cases and stuff that they've been involved in. But I definitely wouldn't expect to see any kind of federal RICO case. Like if the feds wanted a RICO case, they would have, they could charge it. They would like try to take over from the state. And then also I think there, excuse me, would be a double jeopardy argument attached to that. Anyway, I'll be right back here. Here.
I argued this before the recused judge, and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost, and then the Supreme Court of Georgia denied cert.
Okay.
But it's So there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it.
Sorry, I actually just had to kind of put that on because I was getting a cough on. Had to go get it out. But that's another thing that's coming up that I just don't think is going to get anywhere. But Brian Steele is arguing the indictment is defective because it does not say anything about knowingly joining a gang or joining a.
Go ahead.
Okay, well, it's
Go ahead.
a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page.
Okay, got it. Page 90.
Okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity.
Sorry, this goes on for a kind of long time, and it's actually kind of a boring clip. He goes through a lot of case law, but she invited him to refile his motion, so she's going to reconsider that. But it seems like the kind of thing, if a judge did agree that the indictment was fatally flawed and dismissed it, it would be dismissed without prejudice to allow him to reconsider. But I don't think that's going to end up being all that significant. But it is an example of how they're getting a little bit more from Whitaker than they thought previously with Glanville. Oh, did she already? Somebody said she already denied it today, the dismissal of the indictment. If she did, I haven't seen it, but it's a little hard to keep up with all their filings. Oh, here it is. Here's the ruling. Yeah, I wouldn't. Yeah, and look how quickly she denied it. Oh, it's here. It's Thugger. Yeah, I mean, and it's just kind of weird that, like I said, if she did grant it, it would be granted with prejudice or without prejudice, so they could just refile with the indictment. But yeah, she rejected that. Here it is. But yeah, I'm wondering, most of this stuff is like not being, he's not winning like the major stuff, but I think I just think the attitude she's taking with prosecutors can be seen as a win for them on this. But it's going to be interesting to see how he reacts to the ex parte ruling, because she's made it pretty clear she is not going to rule in their favor on that. And she's already taken issue with, some of Brian Steele's characterizations of it and some of the characterizations of Max Shard about the June 7th. So, but yeah, somebody asked if she gave no. And that's the thing, like, in the end, I mean, as somebody put it, like, Brian Steele's actual legal argument to disqualify the prosecutors was not very good. I mean, his original motion really didn't even have any legal argument to disqualify him. He made the argument about them being witnesses orally. So yeah, I mean, somebody says he knew she'd deny the certification. It's like, yeah, certification is when there's actually like a controversial legal issue and something debatable there, and there just wasn't here. So excuse me. somebody asked what the certificate would do for Steele. It would enable him to appeal it to the appellate court right now. But I mean, it's not like the appellate court would grant that. But it was denied. So tomorrow at 8:45, I'll get everything set up for you guys. 8:45 East Coast time. But one thing I wanted to bring up was the judge, and I think I already showed this, but the judge kind of urging everyone to be calm, because I have kind of noticed that. Like, I mean, she was saying it like we get so enamored with one side, we don't take a calm, a deep breath and a step back to kind of look at things. And frankly, guys, I kind of noticed that in the chat when I said, you know, the judge got mad at the defense for not being ready, and people just freaking exploded. No, that's not it. It's like, yeah, actually it was. Like, there's just kind of everybody is just like the passions on this. Like, you need somebody to like be able to be neutral about things and like look on both sides. And it seems like this judge is doing a good job on that. But I liked when she apologized or said she shouldn't have said hell. But, and I meant to put this on Twitter because it's kind of a good call for the masses. She even talks about society in general, but
it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. I should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. This was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right.
so yeah, so that's what we're waiting on here. And again, I think it's pretty obvious she's not going to grant a mistrial, and she's going to issue a ruling about those ex partes that the defense doesn't like. But I do think there's a chance that she's going to take the DA to task over some of those comments just based on what she said. But good show, Meghann. Thank you so much. But I saw somebody. I saw a comment in here. I wanted to saying that. This. I'm not so sure about this. See, the best chance that they have at winning this is a mistrial. If they go to the jury, they're cooked real bad. I'm not so sure. Like right now, if it went to a jury, I don't see how they can say that they've proven RICO, and especially the Donovan Thomas murder. Like when you look at what they've actually presented on that, how can they convict Shannon Stillwell and Diamante Kendrick of Donovan Thomas's murder? Like based on what? I mean, they barely have like any concrete evidence of anything in there, especially anything pointing to those two on it. So, I mean, I think right now, I mean, I would agree that, and I did agree with Max Shard that they're winning right now. The catch is, of course, the case isn't over. And when you read through the indictment of like what's coming, it's like, okay, some of this stuff sounds really bad for them. Like Shamel drinks, we really have not heard anything about that, but they talk about how they have like surveillance video or something of that. I don't know, but it's frankly kind of hard to believe what's in the indictment just based on how things have gone with the presentation of evidence so far. So I don't know. It's just hard to predict, though. It's like, because I'm not the jury. I don't see the jury every day. I couldn't say how they're doing, but I would not think that it's just a guarantee they're going to get convicted, especially on the RICO charge. You know, that's such a big charge. So I'm not sure. But again, the key on that is we are not done with the trial. There's still a lot of evidence left to be presented. God, somebody's still going off on Tory Lanez. Nobody cares, dude. At least not in here. That's not what this is about. And I'm not saying in general. I'm going to do another story on the Tory Lanez appeal. We'll have a video where you guys can all yell at me on that. But this is Yeah, somebody says the Donovan Thomas murder is so confusing. Do you guys remember when they were going over the family tree? And the family tree stuff is just like, okay, guys, I don't think the jury is going to follow this, but they're asking Donovan Thomas's mother about the relations between men that he considered his brothers, because there's like a half brother and stuff. And she was getting confused. She was like, wait a minute. Like, so, I mean, the idea that the jury is tracking any of that. And then the whole purpose of this Donovan Thomas family tree is just to try to show all the, like what was going on before, like the beef between If Gang and Young Slime Life. And I know part of the point in the point of the questions about this is to just get it out to the jury what Woody's beef was with like Donovan Thomas's half brothers, to try to show that, you know, this is not why Donovan Thomas was killed. But the way it's like so slow and piecemeal, it's like, it just seems like the focus is all on that. It's like, it's the prosecutors are like accidentally establishing a motive for Woody or something. It's just the Donovan Thomas stuff is totally like nonsensical. And the idea that they could get some kind of first degree murder conviction beyond a reasonable doubt based on what they've presented, no way. But they've still got the Chamel Drinks one left that we really haven't heard anything about. And then also Rodalius Ryan's one that's not charged as a separate murder. It's an overt act because that was a separate case. But so we haven't heard everything else yet, but just what we've heard so far, it seems weird. But anyway, I think that pretty much covers it. Again, the big news today was the judge denying the recusal motions against Love and Hylton. And then they are back tomorrow at 8:45 a.m. So I will see you guys then. I will get the stream all ready, and I'm looking forward to giving you guys an update. So see you guys later.